Hello and good evening. I'm Melisa Idris. Welcome to Consider This. This is the show where we want you to consider and then reconsider what you know of the news of the day. Recently, the Law and Institutional Reform Minister Azalina Othman Said said that the government will finalise the separation of powers between the Attorney General and the Public Prosecutor after performing a thorough empirical study within a year. Now, what needs to be in place for the separation of these two roles to occur? And what should a future office of the Public Prosecutor look like? Joining me on the show is Aira Azhari. She is the Senior Manager of the Democracy and Governance Unit at the think tank Institute for Democracy and Economic Affairs, better known by its acronym IDEAS. Aira, thank you so much for joining me on the show. Let's start with the basics, essentially. Why is it important that we keep these two roles, the roles of the Attorney General and the Public Prosecutor, separate? How do the fused roles potentially lead to conflicts of interest?
Hi, Melissa. So the answer to that is actually quite straightforward. So the Attorney General is supposed to be the chief legal advisor to the government, and the Public Prosecutor is supposed to be the sort of chief lawyer that prosecutes criminal cases in the country. So when these two roles are fused, we can see why conflict of interest can happen. So for example, if the person committing the crime is someone from government, a politician, an MP, a very high profile person, then when these two roles are fused, as they are in Malaysia, then what is stopping the Prime Minister or someone holding a very powerful office to tell the Attorney General, hey, look, do not prosecute this case because this person is a very high profile politician, is my ally, is my best friend in government. So this is why the two officers need to be independent and separate of each other. And I'm not just saying this, there has already been examples in our country where the Attorney General, has been removed or fired even by the Prime Minister, just because he was allegedly bringing up a case against the Prime Minister, which was what happened during Tan Sri Abdul Ghani Patayil's time at the height of the 1MDB crisis in Malaysia, right? We all know this. So this has already happened, and this is clearly an affront to the rule of law and also equality before the law in Malaysia.
Okay, so you say it's pretty straightforward, the benefits of separating these two roles. But what challenges or resistance might arise from the government trying to do this, advocating even for the separation of these two roles?
So the fusion of the two roles is actually it's complex and it's difficult to sort of separate. Mainly, I think one of the reasons is because it has been fused ever since independence, ever since our country was formed. So that has been the status quo all this while. Unlike some of the reforms that we need in Malaysia, where, for example, with the Parliamentary Services Act, where we had the act for a while and then it was removed, and then now we have to sort of revive it again. But for the roles of the AG and the Public Prosecutor, it has always been fused ever since Malaysia was formed. The fusion of the roles is institutionalized in the constitution and also in several laws actually in Malaysia. So for that change, for that separation to happen, several laws need to be amended, the constitution needs to be amended. So the bar is really high, so that's why it is difficult. And I'm not surprised when the law minister recently said that it will take about a year, because just I think the practicality of it, but also sort of just gathering the support that you need for changing all these laws and the constitution will take a while. Yeah.
Right. Okay, so let's think through, if the roles were to be separated, I'm curious to understand what the new roles would look like or should look like, Aira. Let's talk a little bit about the public prosecutors, the Office of the Public Prosecutor. What would the duties be? Who should they be answerable to? How would they be appointed? How would they be removed? Talk to me a little bit about how to ensure that this office remains separate and independent.
Yeah, so if these two people are independent, these officers are independent of each other, then what we envision is something similar to the UK system where the Attorney General is a cabinet minister. So he is an MP, he's a cabinet minister, which means that he or she serves at the pleasure of the Prime Minister or as long as the government lasts. But the Director of Public Prosecutions, or we call it Public Prosecutor, is an independent appointee. And there should be an independent appointment process to appoint a public prosecutor. So, there could be some sort of hearing mechanism or, something that is transparent, a bit more transparent and accountable where, at least as a Malaysian, we are sort of privy to the process. And this is the problem with a lot of things, a lot of appointments in Malaysia, right? Things happen at the highest echelons of government and political positions. And as Malaysians, we don't know what goes on there. So according to the UK model also, the Director of Public Prosecutions has sort of a dotted line relationship with the Attorney General's office because of accountability reasons. So because the AG is a cabinet minister, so he can debate in parliament and join parliamentary proceedings. So this is where he then presents the report of the public prosecution's office, and that is the accountability mechanism that they have over there. So that is something that we could emulate, maybe not all of it, according to what's suitable for Malaysia. So currently we have a system where we have an AG fused with the public prosecutor, and we have a minister of law, which I'm not sure if that is best practice really. Yeah.
Okay. All right. So help me think this through. So if we had a separate office of the public prosecutor, this person would be accountable to the Yang di-Pertuan Agong, because you talked a little bit about how previous AGs have been dismissed due to not being aligned with what the executive wants. So who should the public prosecutor be answerable to?
Yeah, so that's a good question, really. The public prosecutor could, the mechanism could be where he or she is appointed, of course, by the Yang di-Pertuan Agong, but through a process where perhaps there is some sort of committee that sits, a selection committee. So if I'm not mistaken, the judiciary has a judicial appointments commission, right? So, perhaps a similar kind of commission could be set up, and there is a sort of a more transparent appointment process, and there is security of tenure for the public prosecutor where it says he or she will serve for a certain number of years, and if that person needs to be removed, then it is a high bar. So basically the requirement is similar to how you would remove a judge of the federal court, right? There needs to be a special tribunal and all of that. So I think if we put those safeguards in place, then the public prosecutor can be safeguarded from political interference, which is harmful. Yeah.
Okay. The other thing that you mentioned that I found quite interesting was you said the Attorney General should be an MP, and so a minister essentially in cabinet. Help me think that through. Why should the Attorney General be picked among the members of Parliament? And might there be tensions between the role of a politician versus the role of an Attorney General?
Yeah, so firstly, the rationale for why we propose that the Attorney General should be a member of cabinet is because of accountability purposes. So if you are a member of cabinet, you're an MP, then you sit in cabinet meetings, you are answerable to Parliament for your decisions, right? Mm-hmm. And of course, there will be situations where the Attorney General's position will be conflicted because he's also an MP, a politician. This has happened in the UK, in several occasions prior to the invasion of Iraq in 2003, for example. So what they have over there, and what I think is something that we can emulate maybe in a law in Malaysia, is that there is a sort of conditions where the Attorney General needs to justify his or her decision to the public. And, in cases of public interest, right? For example, the Attorney General cannot just simply decide to prosecute or not, to defend the government or not. There needs to be a process where he needs to justify his decision. So those things can be discussed and debated, like what are the conditions that need to be in place, or the check and balance mechanisms that needs to be that the Attorney General needs to be subjected to. But why we are suggesting that it should be a cabinet minister, because that will come with the sort of ministerial responsibility and accountability mechanisms that comes with a member of parliament.
Aira, you and Ideas have long been, calling an advocate for the separation of powers of these two roles, AG and Public Prosecutor. It's been talked about in many different iterations of government, and we've not yet seen follow through on it. Are you optimistic that this time around, say I speak to you a year from today, inshallah, might we see these two roles, this key institutional reform, be in place?
So I think there are several answers to that. Firstly, I do think that there is an appetite for some institutional reform. For example, the Parliamentary Services Act, has been said it's going to be tabled in the next session in October. So that's really encouraging. If we do see the PSA return, then I am optimistic that there will be movement on the separation of the AG's office. Secondly, I think for this government, even politically, it is really important for the separation to happen, because as we all know, all the cases that's going on against very high-profile politicians, a lot of it, the opposition is accusing the government of selective persecution, of conflict of interest, and all of that. So with an independent AG and Public Prosecutor's Office, then there is less reason for those kinds of criticisms, right? This is why independent institutions and check and balance is so important, because with whoever who comes into power, it's very easy for the opposition to just accuse them of selective persecution if these roles are not independent. So I think it is imperative for this government to show that, hey, look, we are not selectively persecuting anyone. The AG is an independent person, the Public Prosecutor is an independent office, so they are just doing their job. Yeah.
Aira, thank you so much for speaking with me. Aira Azhari from Ideas Malaysia. We're going to take a very quick break here and consider this. We'll be back with more. Stay tuned. Hi, welcome back to Consider This. I'm Melisa Idris. Let's continue our discussion about separating the roles and the powers of the Attorney General and the Public Prosecutor. The government has already pledged to finalise this key reform after performing a thorough empirical study that they say will be completed within a year. My next guest is lawyer Sin Yew. Sin Yew, thank you so much for being on the show with me today. There's this oft-quoted aphorism, justice must not only be done, but must be also seen to be done. And I wanted to talk to you about this. How do you think the separation of the powers of the AG and the Public Prosecutor can contribute to achieving this principle?
Thanks, Melisa. I think the first thing that we need to take into account is, why do we need to separate these two functions? And if we look at Article 145 of the Federal Constitution, the Attorney General he is the principal legal advisor to the government in his capacity as the Attorney General. And he is also the principal authority in deciding whether or not to initiate legal proceedings against someone who has committed a crime. So he has two functions. And the problem with that is that there is a very clear case of conflict of interest, not just in theory, but in practice as well, as we have seen. And I will bring up one or two cases later when these two roles are fused. Because if you are the principal legal advisor to the government, and you also get to decide who gets charged or who gets prosecuted in the courts, then when it comes to a case where a person is a powerful figure in the government, I think you know who I'm going to speak about, then that role, the function of the Attorney General, becomes very problematic, because he would be in conflict of interest in both advising as well as deciding whether or not to prosecute. So,
Right. So, right now, as it stands, technically speaking, who is the Attorney General's boss? Who is he answerable to?
Well, under the Constitution, he is his boss is he serves at the pleasure of the Yang di-Pertuan Agong. But as we know how the role of the Yang di-Pertuan Agong is, the Yang di-Pertuan Agong acts on the advice of the cabinet. So that would put the Attorney General under the cabinet or under the Prime Minister. So in theory, again, he serves at the pleasure of the Yang di-Pertuan Agong, but in practice, he takes instructions from the cabinet, from the Prime Minister.
Okay, help me think that through, because that in itself is the conflict of interest you were alluding to. But there have been people who've pointed to the fact that, well, isn't that the nature of being a legal advisor, that there is a client-lawyer relationship, so that the client can dismiss the lawyer if so be it, choosing to replace him or her. Is that how we should be thinking about it?
Well, for most cases, I mean, in the day-to-day running of the prosecution unit, the Attorney General doesn't really get involved. It's only cases where there's a powerful figure of government who is being investigated, who has a case who has a case filed before the Attorney General. Then, questions of conflict of interest would become more apparent. Of course, it's not every single case that the Attorney General would decide that, oh, I'm not going to prosecute, or I'm going to take instructions from the Prime Minister, I'm going to take instructions from the Cabinet. No, I'm not suggesting that. But what I'm suggesting is that when a decision is made on whether to prosecute, then a lot of questions on his role would be launched at him and launched at the government, whether or not there's actually any governmental or political interference. Because effectively, what a lot of the public would have in mind is that, why is the principal legal advisor of the government prosecuting a powerful figure in the government? Because you're basically prosecuting those who you are, you owe your, how do I put it? You would have your role be your, how do I put it? Your position would be threatened if you do not act in their interest.
Yeah, there's a certain vulnerability, fragility to the role because of who your political masters are. Can I ask you to envision the role of the office of the Public Prosecutor as an independent and separate office? How would that look like if we were to separate the two roles? And bearing in mind that this will probably be something that we would have to draw out or design for Malaysia. It's the first time we're trying to do this. How should we do it? Make sure that the design of this role, the separation of the powers, is done right.
Well, first, the office of the public prosecutor, it needs to be, like you mentioned, independent, and it needs to be separate from the government. So that would entail a number of things. First, it would entail amendments to the current laws, Article 145 of the Federal Constitution, the Criminal Procedure Code, a number of other acts, including the Interpretation Act, to separate the role of the public prosecutor from that of the Attorney General. And then the other thing that we need to consider is the appointment process. So the appointment of the public prosecutor, it needs to be transparent, and it needs to be an independent process where hopefully there could be a committee of sorts, I think a selection committee that wets through any candidates that is submitted by the Attorney General or by Parliament or someone else who may want to apply for that job, and perhaps subject that process through Parliament and vote on it by way of simple majority. And the public prosecutor should also enjoy security of tenure, and that would require his removal to be perhaps the removal process to be difficult, such as having 2/3 requirement by Parliament, or some other process where he could not be freely removed by the executive, as we have seen with the case of Tan Sri Gani Patayal. And that episode, which was what I was trying to allude to in those secrets, it sort of sparked the debate, and it's not something new actually. This whole talk about separating the role of the AG and the PP, that has been ongoing for many years, even back to the times of, I think, the 1980s. I think Lim Kit Siang, Tan Sri Lim Kit Siang brought it up, when it concerned the building of highways, and so it's not something new, and I think it's definitely time for us to not just talk about it, because we have talked about it for many years, many decades. It's time to act on it, and political will. That's something that is sorely lacking.
So correct me if I'm wrong, but the idea of combining the two roles was in the Constitution, done before, at the start of the formation of the country, and the idea was so that so that we kind of coordination, or kind of consistent approach to legal matters. I'm curious now that if we were to separate the two roles, how do we ensure that relationship between the AG as a legal advisor to the government and the public prosecutor as an independent prosecutor for cases? How do we make sure that it is safeguarded from political interference, from executive interference?
Well, when it was fused during the formation of the country, I suppose the framers of the Constitution thought that at that point in time, there was a very high level of governance and integrity, and there was also a lack of resources. So there weren't that many human resource that is trained in both prosecution as well as other legal matters. So and that really is also the reason why it's a separate matter, but that's also the reason why there was the judicial and legal services, where the attorney, the AG sits in the judicial and legal services, but that's a separate matter altogether. But I just want to highlight that at that point in time, times were very different. Now you have a lot of lawyers who are trained to both advise the government as well as prosecute. We have many universities that have churned out, law students by the dozens. So it's a bit hard to say that the same circumstances which applied back in 1957, they will still apply here. But I would like to touch on the fact that within the Attorney General chambers, of course, I'm an outsider, and I suppose somebody with better understanding of it would be able to comment on it. But within the Attorney General chambers, they have separate units. You have the unit on foreign affairs, you have the unit on prosecution, you have the unit on civil matters. So internally, there is separation of sorts. So in practice, it is separated. But in theory, and it comes to cases where high-profile cases, for example, that those practical separations, lines between them becomes very blurry, and it doesn't really inspire public confidence when any decisions are made. So the separation in theory, as well as cemented in law, is actually good, not just for the rule of law, but it's also good to insulate and protect these institutions from criticisms. Because any decisions that is made, even though it is meritorious, it could be attacked based on the mere fact that the Attorney General is appointed by the Prime Minister, right? On advice of the Prime Minister. So it throws a very dark shade on a lot of the decisions that are made, and which may not necessarily be fair to the Attorney General.
Well, separating the two roles will definitely build public trust in our institutions. Sin Yew, thank you so much for joining me on the show today. We appreciate your time. That was Lawyer News Sin Yew wrapping up this episode of Consider This. I'm Melisa Idris, signing off for the evening. Thank you so much for watching, and good night.